right, welcome everybody to the Rhinebeck Zoning Board of Appeals meeting for September 15th, 2021. One thing I want to mention just before I get going here, because I'll forget it. This may be our last open meeting for a little bit.
In person.
In person, yeah. It's an open meeting, but in person. We may be going virtual for the next meeting and some meetings after that, depending on the way of the world and the situation. So I just want to put people on notice of that we may be virtual, but we can.
So because it's unknown, I would suggest check the way that the meeting will be held will be posted on the town website in advance of the next meeting. And so we would urge you to check the website just to make sure so you don't come here, especially those of you who are traveling, that you don't come here and then there's somebody here. And then we'll discuss the date of the October meeting later in the...
Yeah, we should be good because Tim will be here.
Okay.
Yeah, he was just on vacation last, so we're good. Keep that. All right. Did everybody get a chance to take a look at the final version of the meeting minutes for August 18, 2021?
I sent around some comments this afternoon. I don't know if you've had a chance to
Right.
see it.
I took a look, I think, at the last version that you had.
Yeah.
Yeah. It looked good to me. I don't know if the rest of the gang did. Yeah, it looked fine? Okay. Any questions, concerns, or? No? Okay. All right, then I make a motion that we accept the meeting minutes for the last meeting, which was August 18th, 2021, as presented in their last form this afternoon. Do I have a second?
Second.
All right, all in favor? Aye.
Aye.
Opposed? Okay, abstentions? All right, carried. All right, that takes us to our first matter, and that is, we have one piece of new business, and that is is it Asnato?
Correct.
Okay, just wanted to make sure I was pronouncing it correctly. That application, so come on up and we'll get you set up. Kim should be able to assist you there. We have a pretty good idea of what you want to do.
Okay.
But just kind of explain to us
Sure.
the application, and all we're doing tonight is to determine whether the application is sufficient, and if it is, we'll accept it and we'll set it up for a public hearing.
Okay.
All right, so have at it.
Shall I set up my easel over there? Or?
Yeah, you can set up your easel over there, and if you can speak into the mic.
Sure.
And Jordan, let me know if you have any issues as far as sound or anything. Best spot.
Can you guys see that okay?
Beautiful.
Hello. Hello.
Hold on.
Hello.
Probably the math
Hi.
is not helping anything.
My name is Richard Countryman, and I'm representing my client, Michael Azevedo, for a solar ground-mounted array behind his house. The issue is that there is a 150-foot setback from the side lot boundary in this district, and the ground mount will be located 100 feet from the lot line. So we are asking for a variance. It was suggested that we request a 50-foot variance from the side lot line to make sure there's plenty of room. We have gone through the planning board approval process and have an approved site plan by the planning board, and the last step is the variance for the side lot setback.
Okay. And can you just show where it's going to be? I think it's on the lower right-hand side. Yeah, right there. And then
This
also.
piece of beer.
Okay. I took a look at the application, and I didn't have a quarrel with it as far as its sufficiency, but the one thing I do like to get
Sure.
are renderings, and I'm sure you probably provided them to the planning board, so whatever renderings you had, elevations, that kind of stuff, if we could get that for our consideration.
Certainly.
And we'll have to do a site inspection, so I don't know if it's staked or some
It can be.
Yeah, we would ask that it be staked, so when we go out there, we actually see where it's gonna be and
Certainly.
that kind of stuff, so.
Yep.
Those were the only considerations I had. I don't know about the rest of the gang.
I do have a topographic map with it superimposed behind the house so you can see the contours of the elevation. If you would like me to pull that out now, or if you'd just like me to send it to you via email.
Yeah, if you wanna pull it, or Kim, if you have it, that's great. Otherwise, we can just, get it through. You can send everything to Chris, and she'll send it on to us, and we can have it.
Okay. So for in preparation for the meeting next month, you would just like the complete engineered site plan and the ready to be staked out?
And yeah, any renderings, something showing where it is vis-a-vis the house. I know you have it in one of the things, but just really show like the elevations and where it is.
Yeah, you can see the contour lines here. So each one is 5 feet, so it's spanning less than 15 feet of elevation change. We plan to step the array down as it follows the grade.
Do you have some kind of illustration of that? Was that provided to the
I
planning
can
board?
provide an example that we
Okay.
have built.
I mean, I don't want you to reinvent the wheel, but whatever else you provided to say the planning board and their considerations would be helpful for us.
Sure.
So
Yeah,
I know, I'm familiar with the road, and I know that it probably slopes down right from the road, so it's not visible from the road. How is it
Correct.
from
Here's
the,
Morton Road here.
it slopes down, right? There's a pretty,
Yeah, the driveway actually does a long, windy route down to the house, so you can't see it at all whatsoever from the road. I believe it's 1,300 feet from the road, and there's vegetation, like really successional shrubbery growing up in between the road and the where the house is.
any landscaping or planned or existing between where this array will be and the neighbor?
So there is thick vegetation all through this 100 feet here that provides a very large amount of screening to the neighboring property. Joe and I forget the name of the other woman who came out for the site visit from the planning board. They looked at it and they did deem it to be sufficiently screened from the neighbor's property.
And no vegetation plan to be cleared?
Nope, we don't plan on clearing anything, regrading anything. It's a very short trench to get to the house. It's only about 50 feet or so.
And is there vegetation also on the neighbor's side between their house and the property line?
There may be. On this image, you can see the tree line does go a little bit past the lot line. Especially right here, there is kind of like a large outgrowth of trees, and the house is right there.
I think I pulled up this is just a picture from parcel access, but it might kind of have.
Oh, yeah.
Yeah, it's very heavily wooded in here.
Okay.
And it's not just large trees either. There's a good mix of vines and all kinds of varying sizes of bushes. So even in the wintertime, once leaves fall down, there'll still be a ample amount of screening, we believe.
So, which way will the modules be facing?
Facing south, so it is perpendicular to the waterfront.
Okay.
So the view from any part of the river is minimized by the side profile of the array opposed to the glass front. And because it drops off steeply here, you can't see it unless you're all the way on the other side of the river. When the planning board came out for the site visit, they also deemed the view shed to the waterfront to not be of a negative impact.
And then, so all the wiring is going to be facing the neighbor north of it, right?
Yeah, on the array there will be there'll be a combiner panel. It's just a small sub panel, and that is all. And then all the wiring will be underground to the house.
You've already received your planning board approval.
Correct.
This has a copy of the planning board resolution been submitted with the application.
It may have been. I'm not 100% sure. It's not.
That's right, we'll get a copy of
I
it.
didn't see it.
Yeah, Vicky, our
Yeah,
office
if you could just send it in when you
administrator.
send in the renderings, that'd be great.
Will do.
And we have to refer to the planning board anyway for their consideration, so.
Sure.
We'll get their input, but that's nice to have.
Okay. Do you have any other questions for me tonight?
I don't have any other questions, but let me ask my board members. Anybody have any other questions about this application? Okay.
Looks good.
All right. So then, I'll make a motion that we accept the application, subject to receiving the additional information.
Certainly.
Do I have a second? All right, Richard. And
Thank you very much.
all in favor?
Yes.
Aye.
Aye.
Opposed? Abstentions? All right, we'll set it down for a public hearing, which is going to be October 20th,
We hope.
we hope. Well, it should be October 20th. And is that a date you can make?
Sure.
Okay,
I'll
great.
make it work.
All right, so what'll happen is, the notice will go out, the public will be notified, the surrounding folks, and they'll have an opportunity to come here. You'll present again, answer questions, et cetera, and in the meantime, if you can, try to stake it at some point in time, and, because we will be going out, because we're gonna wanna see for ourselves, the vegetation and all that kind of stuff from
Sure.
where it is. and-
Yep, I can mark out the four corners, so
Yeah,
it's very
that's
clear.
fine.
Sure.
And that'll give us a good idea of what you're doing.
Okay.
Great.
Richard, are you the point of contact for the arranging the site visit?
I can be. Vicky is our office administrator who handles most of the permitting for jobs, but I'm usually CC'd on all the emails with her
Okay.
for projects that I'm doing as well. So
All right, well, we'll see you on the 20th.
great, thanks a lot.
So we have a little bit of housekeeping.
Thank you.
Thank you. The planning board has already deemed it to be a type 2 action, so obviously we'll look at that. Referrals are to the planning board and also to the WAC. Okay,
Yes, it's just with, close to the river. it's
Right.
better than,
Yep. All right. Do I need to make a motion for that, or we just?
No.
You can just, you can just
Okay.
direct Chris to send that out.
All right, so we just have those two items, and then we need somebody who is willing to write the resolution.
I think I will.
You're up? Okay. So Tim has graciously volunteered to write it up. All right. I miss anything, Kim?
No, you're good.
All right. All righty, so that brings us to our main event, so to speak. The continuation of the public hearing on the Red Wing application. And I'm not sure, and I'll defer to council. Kim, should there be a motion to open the public
Yeah,
hearing?
motion to open and continue the vote.
Okay, so I'll make a motion at this point in time that we open and continue the public hearing. Do I have a second?
Second.
Okay, all in favor? Aye. Opposed? All right. Okay, the last time around, I thought we had a great discussion from both sides about the issues in the case, and that was fantastic. And it was done in a civil manner. Everybody presented themselves in a exemplary fashion, and I really appreciated that. I just hope, and I'm sure it will happen, that again, I know everybody has strong feelings about the application in one way or the other, and everybody has their opinions. Again, we're known for our civility, and I'm sure we're going to stick to that. Strong opinions are great, but I just don't like strong words. And I have this weird condition that when I hear people yelling and getting obnoxious, I don't hear them anymore. So it's in your best interest to be civil. I'm sure everybody will be. And with that, I think I will ask that the applicant get up and again present. Now, the other thing is everybody who wants to speak on this matter signed in? Because we do have a sign-in sheet up over here up to my left. I'm sure everybody's familiar with the process, but we want to try to keep it as orderly as possible. So, sign-in sheet. So we have a couple of folks. Great. All right, so what I'll do is after the applicant has the opportunity to present the application, I'll call folks in order to come up. I'd ask that you state your name clearly and loudly, not angrily, but loudly, so that Jordan can hear you over here. Give your name, your address, and ask whatever questions, give whatever opinions you have.
with the board's permission, would my client be able to speak right after me? So
Sure,
I'll
that's
be
fine.
as his counsel.
That's fine.
He did sign up right after mine. Good evening. As most of you know, my name is Ryan Kelleher. I'm with the law firm of Bond, Shenik & Kin, and I represent Red Wing Properties, Inc. You've heard my argument numerous times. I've made 2 submissions as well. I'm not going to go through every single detail. The main reason why I'm up here again today, 1 is because we've continued the public hearing, but 2 is also to respond to some of the comments that have came in, and more importantly, the town's written submission and the tour letter as well. So we're really here for two issues. Number 1, did Red Wing violate the town codes that were on the notice of violation letter as of April 27th, 2021? And then the second issue, which is really more of the larger issue, is does Red Wing need a special use permit and site plan approval to build and use a mine access road? So taking the first issue first is the violations. And as the ZBA has heard numerous times, the only thing that had occurred on April 27th, 2021 was the removal of a handful of trees. And I spoke with my client again today. He said it's somewhere around the neighborhood of like 10 trees, maybe less. That's all that was taken down. That's the only thing that was done as of April 27th. And from April 27th to May 20th, when the Red Wing and through counsel myself filed a notice of appeal, nothing else occurred. No other trees were taken down. There was no stone laid down. There was nothing. None of the turtle underpasses. Nothing was done until May 20th. And that was the date of the notice of appeal when the violations were stayed or when the cease and desist was stayed. So why do I bring this up? Well, I bring this up because we're here to see if Red Wing violated the town code, the town laws of April 27th, and we submit to you that we absolutely did not. The taking down of 10 trees is not a violation of any of the laws. Now, counsel for the town has cited to section 125-68 NN, and incorrectly in his paper said that we never addressed this. As I indicated, that was absolutely incorrect, and for the ZBA's attention, I would like to draw you to pages 9 and 10 of our original letter, as well as footnote number 4 in our reply letter. And we absolutely argue that that doesn't apply, and it doesn't apply because this section specifically states that it's not applicable to extractions and soul mining. So it either doesn't apply for that reason, or if it doesn't apply, or if it does apply because we're saying, oh, we weren't mining, this wasn't a mining, that was part of the town's argument in their most recent reply letter, as well as a tour letter that, well, they can't have it both ways. Red Wing can't have it both ways. They can't say they weren't mining and then say that this code doesn't apply because it falls in one of the exceptions for mining and soil. Or it doesn't apply to that, and it does apply because they were removing trees. But if you look at the code, it specifically says major tree excavation. So I hardly think the town, when writing the code of major tree excavation or removal, was discussing 10 or less trees. So it doesn't apply for one of those 2 reasons. Either it was mining activity, so it doesn't apply, or it wasn't mining activity and it wasn't major tree removal. And just to talk about the submissions real quick, and I don't want to get tit for tat, but Mr. Bergen specifically said the last time we were here that our submissions were due 1 week ahead of the town's ZBA public hearing. We complied with that order, and respectfully, the town did not. And not only did they not comply with that, it was 5 days late, and all they did was respond to our arguments and our reply. So, respectfully, I don't think that letter should even be part of the record. I think it should be thrown out. Mr. Bergen specifically said the CPLR does not allow for a surreply, and that's exactly what they did. And then with the tour letter, I'm not sure that's even allowed to be submitted anyway. It's not a town resident. It's a law firm that has been hired as a hired gun to submit a letter. I'm not sure what the law is on that, but again, that was submitted 3 hours before, or 2 hours before I had to get in my car and drive down here. I did have a chance to look at it. And I'm not sure if Mr. Bergen's orders had to do with just the town's reply or whether it was, town residents, but I just wanted to bring that up. Again, I don't want to get tit for tat for it, but I do
The
think it's
spirit of it
important.
was that everybody respond and give us an opportunity to digest it and all that. And we don't typically not look at stuff that's searched quote unquote late, but I will certainly give you an opportunity to respond to those items, because I think that's fair, since you didn't have an opportunity. And so you can have a serve reply, which is even more not countenanced by the CPLI.
Well, I thank you for that.
And just to say too, that the public hearing is technically still open, so nothing, there wasn't really it was more of a courtesy kind of.
I completely understand that, but the order was, and again, I don't want to get tit for tat for this, the order was, we're not giving a cert reply, everybody submit your papers 1 week ahead of time. So therefore, I didn't have the courtesy of looking at all their arguments and seeing all their arguments, and they did, and if you look at the reply papers, all they do is address my arguments. They don't say anything about the last hearing, they go through, Kelleher said this, Kelleher said that, Kelleher said that, or the Kelleher letter said this. So that's all I'm saying, we'll leave it out there, I understand.
You have the
both
opportunity
sides.
to respond.
Thank you. So going through those dates, we didn't do anything, Red Wing did nothing from May 20th. I think what's important here is as of April 27th, which are the only violations and the date that is applicable here, the only thing that was done was trees. That section doesn't apply. Red Wing certainly did not violate the law as of that date, which is the date that we're here for today. And just another thing is, Red Wing has not tried to hide what's going on. We submitted photographs. You guys all have them. We talked about them the last time I was here. There are photographs of what has occurred. They show exactly what's occurred. And not only that, we've given the town an opportunity, which you guys took up, and I think there was 4 or 5 people that attended that meeting, down at Red Wing's property to walk the entire road. We're not trying to hide things here. That being said, there's certain people in the town that are submitting photographs to, I think, try to get you a gotcha moment. We got you did all these things and you didn't tell us about it. No, we told you guys about it. And again, I think that those photographs are, if they're evidence of anything, it's evidence of trespass. And we kindly ask all of the residents of Rhinebeck to not come on Red Wing's property. I think that's important. The photographs are clearly taken on the property and it's clearly trespass. I've talked to my client about it and we're going to be determining what we're going to do. But we ask nobody else to come on. There's signs on there, there's trespassing, and we now have video cameras set up. So I'm just asking the town as a kind courtesy, please do not enter our property.
Okay, I don't think any town people have. I mean, town people who are residents of the town may have.
Oh, yeah.
I know we have not.
Correct, yeah.
And that is another thing I was going to ask you. I'm sure that everybody here is very interested in going out and taking a look at the property and the roadway and all that. So at some point in time before the next meeting, we would like to schedule our ability to go out. I know the planning board, I believe, has been out, or some other, maybe the town board. The town board has been out.
Town board, right, and I was not trying to insinuate there's anybody on the ZB.
No, I know, but I just, it prompted my recollection of an issue I wanted to address, and that is
Sure.
the town board. I know we would like to have the opportunity since we're considering this.
Absolutely. So then this brings us to our second issue, which is the larger issue, the special use permit and site plan approval. I've gone through my argument numerous times. It's in our papers, it's in our reply papers, it was in my first argument in August as well, or excuse me, July and then August. I'm not going to rehash everything, but I think the one thing that is important is that Red Wing certainly doesn't think that we have to do a special use permit. We've been clear about that from the start. We also have said that we work with the town if it's to grading or width or attaching it to White Schoolhouse Road. But the special use permit is nothing more than to relitigate all of what we've done over the last 4 years, or probably more than that now. We don't believe that we need to do so. We believe that the court's ruling determines that we don't need to do so. And the town has submitted numerous times that the decision doesn't say this, the decision doesn't say that, or we haven't submitted any proof of this, or we haven't submitted any proof of that. Well, I submit to you the town hasn't done any of those things either. If you look at the decision doesn't say we need to ask for a special use permit, or we have to go to the town for this permission, or we have to go to the town for that permission. So using the town's argument against them, it doesn't say their side either. It's a decision that doesn't say a whole lot other than vested right to mine. So if we're interpreting it one way, town may be interpreting it the other way, but the decision certainly doesn't say, as the town cited in their most recent submission, that the decision simply permitted Red Wing to make the necessary application to the planning board and highway superintendent to mine its 94 acres. That's not what the decision said. So that argument that the town makes can go both ways. And likewise, with the case law, or lack thereof, or support, the town doesn't have any case law saying that in this particular decision that that we need to have a special use permit either. The problem with this decision is it is a little vague, and there's not any case law that interprets it. So this is almost a first impression in some ways. And you know, the town has cited some cases, but if you look at them, they don't have anything to do with this. And I'll get there in a second. So the next argument, which I was alluding to, is this judicial stop award. Okay? Absolutely nonsense, to be honest with you. If you look at the case that they cited, the Edson case, all it does is cite what judicial stop awards. It doesn't support their position. It doesn't support anything to do with this. It has literally nothing to do with this. And I urge the ZBA to read that case, and you'll see. And not only that, their argument was, okay, we made some arguments from 2001, and then in 2015 and 16, or whatever the dates were, you'll see in their submission. Well, things have changed. So while our argument may have been something in 2001, guess what? The town law of 2015 didn't even exist. Town law has changed, mining districts have changed, and most importantly, and even if none of those things have changed, most importantly what's changed was we went to the appellate division, as you all know, and we won there, and that's the last court that's ever going to decide this issue. So while we may have been making some arguments at the time that we might need a special use permit, or there may have been some comments about special use permit, that all changed once the appellate division ruled and the Court of Appeals did not take it up to them to determine differently.
Right, but again, the appellate division did not specifically address that issue and said that you did.
Right, they turned it down.
Yeah.
So at the end of the day, the
Well,
appellate
not the Court of
division-
Apples, but I'm talking about the appellate division. They didn't specifically say in their decision, you don't need a special use permit and all that kind of stuff, and you guys do have the burden. So, I mean, I understand you can interpret the decision two different ways, but there's not an explicit expression by the Court of the appellate division that you don't need to have this.
Right, and
It's not-
we're interpreting it this way, they're interpreting it a different way, but there's no support for their position either. That's my point here today.
Okay, but I guess my thing is, and I'm not trying to be difficult, but it's just, there doesn't seem to be support on either position, you know, from what you're saying. I mean, it really,
Well, there's not
it's
case-
it's a case of first impression, and so it can probably be interpreted both ways.
Right, and what we're saying is it could be interpreted, well, we're saying it should be interpreted our way, and while there may not be case law that we cited, that doesn't mean that our argument's wrong. I guess that's.
Yeah, no, and I'm not saying that, and that happens. I mean, I'm an attorney too.
Right, no, I
There are
understand.
times when there is a case of first impression, and you're kind of going in the dark, and you know, you don't have anything to rely on. There's no precedent. So
Right.
that's what I'm getting at.
Right, and I guess the point is, that the town's trying to say, oh, since we don't have case law to support our position, this is a failing position. That's absolutely incorrect. They don't have any case law to support their position either. So anyway, and then going to this argument about appurtenant. And they cite the Partition case. And I think it's probably best for me to go through exactly what happened in that case. So in that case, there was a landfill that was on one parcel of the land, and there was a landfill that was on that parcel, and it was permitted to be there, and it was part of the zoning code. There was an access road, a landfill access road that went to that landfill that was outside of that zoning district, and the town was arguing that because that access road was outside the landfill zoning district, it was illegal because it was appurtenant to the landfill. And I believe the private owner tried to argue, no, it's just a driveway, or it's just a road, and the court found, no, this is an access road. It is appurtenant, so therefore the town's argument that it's illegal may be basis for it to be illegal, but for the fact that there's a non-conforming use for that access road. So ultimately, they found that the road was illegal, but it was from some other nuance because the non-conforming use would only stand for a few years and then eventually end it. But in this case, if anything, this case helps us. It doesn't hurt us. So yes, we have a mine that's within a mining overlay district, and there's a mine access road that goes to that mine. And whether it's a pertinent or not, let's just say it is a pertinent. Well, that appurtenant access road falls within an area outside the mining overlay district. However, because we went to the appellate division and it found that there was a vested right to mine this non-conforming use, there is a non-conforming use for it. So if you look at this case carefully, and I urge the board to do so, you'll see that this is not a case that defeats our argument. It does not find that because this access road is appurtenant, which I'm not even saying it is or not, but if the board finds that it is, it doesn't matter. It's a non-conforming use. The case is clear as day on that exact point. Moreover, that case has nothing to do with permitting. It has 100% to do with whether it's legal or not to be there. It's not a permit case. So that argument fails. They cite another case. I'm not going to get into all the facts on that, but the board can read it. It's not applicable once again. It's even less applicable, really. And ultimately, I'm not going to rehash my whole argument. I think we've been here numerous times, but I did want to address those things that occurred in both the town's first letter and the reply letter, as well as that tour letter. And with the ZBA's permission today, we will submit another reply.
That's fine.
And hopefully that's the end of the replies. But we will do so, and when should that be done? A week before the next, or are we done after this, or how is that going to happen?
Yeah, what my plan at this point in time, and obviously subject to my board members, is to continue the meeting till the 20th, and after the site visit. And that's exactly what I was getting at, John. We want to do the site visit. We may have some more questions, so that's why I want to keep it open until we get an opportunity to do the site visit. So a week would be great, and again, I'll leave that open to you. If you want to make it sooner, later, whatever, it doesn't matter.
Yeah, and it might be worthwhile doing the site visit first, and then we can do
Yeah.
a final
And
decision.
quite frankly, we always consider anything from anybody up until the time that the public hearing is closed.
Okay.
When the public hearing is closed, nothing else. But up until that point in time, we're going to accept stuff because it's important that everybody have an opportunity, even if they're a little late.
And you'll have an opportunity to rebut after the public hearing is closed.
Okay, understood. So, just to close here, based on Red Wing's written submissions, the first submission or second submission, as well as my comments now 3 months in a row here, Red Wing respectfully requested this ZBA dismiss the violations and lift the cease and desist, as well as hold that Red Wing does not need a special use permit and a site approval plan to build their mine access road, as they have a vested right to do so. My client's going to come up and he has a few words to
Okay.
say as well.
Thank you. I'm Frank Doherty, the president of Red Wing Properties Incorporated. And I'd just like to try and clarify some things that have been alleged by the CEO and some public comments. On March 22nd, I contacted Robert Wyant to notify him that we'd be cutting some trees. Can I drop my mask a little, my glasses? I'm fully vaccinated.
All right.
It's okay?
I guess, yes. I'm probably violating some law, but I mean, if you're having trouble breathing and you can't get.
No,
your
I just can't see. I'm fogging my glasses up. And to notify him we'd be cutting some trees on the property entrance. It was pretty much a heads up, courtesy call, just to let him know that there would be some activity there in case somebody called him up and said, what's going on over there? So that's what I did. On March 23rd, I had 2 men with chainsaws and a chipper on site. They didn't start until about 10:30, 11 o'clock that day, so they didn't get much done the first day. They were on site March 23rd, 24th, and 27th. Mostly at the entrance, they removed approximately 10 trees. They went back on April 10th and the 14th to cut some more trees about 1,500 feet into the property because we had gone in with a GPS and realized we had to remove some trees in order to put the road through where it had to go. The Blandings turtle active season runs from April 15th to October 15th. So Between those dates, we are required by our DEC permit to have a licensed turtle monitor on site during any construction activity, anything. We stopped doing any work on April 14th. The NOV was dated April 27th. We received it on May 7th. The NOV alleges that we were actively constructing the road. We were not. All we had done was cut trees. On May 20th, we filed an appeal to the ZEO, which granted Red Wing a stay of the violation, as Attorney Kelleher alluded to before. We started actual construction on May 26th and ended June 15th, 15 days on site. We had a licensed turtle monitor on site every day during construction, and during that time, that licensed turtle monitor trained 2 of my people that are sitting right over there, and they now are licensed turtle monitors by the DEC. While we were there, the licensed turtle monitor, he was there every single day. We found 48 painted turtles, 6 snapping turtles, 0 landing turtles. And every one of those turtles we encountered were moved safely out of our way. One of the biggest issues, and I've been through this process many times, and the biggest issue is always trucks. And I've said things in the past, things change over time. Back in 2001, I probably said we probably had 80 trucks a day, and then I changed it to 50 trucks a day. And things have changed over the last 10 years. I don't know if anybody notices this, but everybody and their brother has one of these little trailers that they pull behind their pickup truck. That's the bulk of our business anymore. But just to prove how many trucks we do a day, this is a tally sheet from September 13th. 23 trucks. A lot of them are only 17, 18 tons. This one is September 8th, 18 trucks. This is at my road jam plant in Milan. And on September 3rd, 25 trucks. And the bulk of those, 4.95 tons, 0.63 tons, 2.95 tons. So you're not talking about all these gigantic trucks running up and down the road. It's not a regular parade of trucks coming in and out. It's sporadic. A rainy day, you get 1 truck. No trucks. 5 trucks. It's not as crazy as people allude to it being. It's not constant trucks coming in and out. It never has been. So with that, I just wanted to clear those things up. And also, the trucks traffic routing, 99.9% of the trucks are going to take a right-hand turn out of our entrance. Go down to Bull's Head Road, take a right-hand turn on that, continue to Route 9G. Most of those will go south. Some will go north. They've got to go into neighboring towns. But most of them are going to go south. And that's the route we prefer to take, and that's the route we'd rather take. So that's really all I had to say. Do you want to add anything to what I had to say, or just want to clear those things up?
Thank you.
Anybody have questions or anything?
Yeah, I do. Are you planning on being a DOT pit?
We
Certified pit?
will get DOT source approval, yes. They're going to
So you're gonna have bigger trucks than,
Excuse me?
you're gonna have bigger trucks than just trailers if you're gonna be DOT.
Not necessarily. Not necessarily.
What is the?
We don't really sell to the state, hardly ever. We just get DOT approval for our sand, generally. The stone probably won't be hard enough. It'll just be the sand, concrete sand in particular.
What is the size of the biggest truck? that you-
Well, we
there?
run triaxles and dump trailers. And I know the town is opposed to the dump trailers. I'd like to at some point get into maybe a pilot program, put 2 dump trailers on a day, making 3-4 loads a day, see how it works. I mean, when I talked to Mr. Wyatt, he told me that it's not a written law, but trailers are allowed to come in loaded, but not leave loaded. Well, what's the difference? If it comes in empty and leaves loaded, I don't see what the difference is. So that's something that needs to be worked out.
Right, but what's actually occurring now? What exists?
What exists now,
Yeah,
I'm not
what's
doing
happening?
anything. I'm not doing anything now. I have nothing going on. I can't touch the place until I get through with this.
Nothing's happened since
If
2013.
I did, you'd have these guys. put me in jail.
That's what I'm getting at. And I didn't say, historically, what has occurred there? What are the biggest trucks that you've had there in the past, when you were operating?
Mostly triaxles, when Jeff Decker was in there. I have never done anything there. We always leased it out to Jeff Decker for years, until 2013, when we had the need to go in there on our own. And Jeff moved out, and we tried to move in, and then we got denied by the planning board our access. And that was the end of that until now. So it's been 6 years, and we've not been able to do a thing. We haven't taken a spoonful of material out of there in 6 years.
Okay, thank you.
Okay, thank you.
Unless you have- right.
Actually, I have a question. When you were talking about the number of trucks a day, that's really determined by the market, not by.
It is determined by the
inside,
market.
right? So if the market goes up.
Yeah, but this is
more
what we
trucks.
typically do, what I just showed you, those are typical days. It could be, and one of those days this week was actually town of Colpack was coming in for road sand, which is highly unusual in September. So I would have only had about 18 trucks instead of 25 that day. But we don't get that many large jobs. Right now, as where all the work is going on, it's crazy. I'm turning down work every day because I don't have enough material. But, you know, one thing I'd like to say is, does anyone in any town put a restriction on how many customers they have? I mean, we're a society where we want to try and make a living, and you can't just shut the gate at noon. Well, we got 25 trucks, okay, everybody go home. You can't do that. And I don't anticipate having loads and loads and loads and loads. I just don't. Unless there's some kind of public emergency, and that is always allowable anyways.
The only point I was trying to make is that I think you can base some patterns on past patterns, but you can't really predict what the volume will be.
No, we're making our best guess. And based on historic, what we do now, what we've done in the past, I used to have 3 plants running, so I had all kinds of trucks running around. Now I have 1.5. I have the one that produces material in Milan. I have one in LaGrange, it's basically a supply yard. And all the trucks that go in there are 2 tons at a time.
And what are the kinds of materials that will be coming out of this one?
Sand and gravel, topsoil,
All 3.
yes.
Thank you.
Thank you.
Mr. Doherty, will you be submitting copies of those truck tally sheets that you referred to?
I can give you these right now, I just printed them up off my
We'll do
computer.
it.
2 days? Okay.
I'm gonna look at it.
Okay. We'll get them to you. I can get you more if you want, I can give you a month worth, whatever you want.
Just the ones you were referring to.
Okay.
So just one last thing, Mr. Brigan, will somebody be reaching out from the board to set up the site?
Yes, yeah, we will. And, but again, and I echo what John said, you know, since they were referred to in the argument, we would like to get a copy of those sheets.
I can get those over to you this week.
Okay. All right, I have the first person up is Mr. Mr. Trimble, Michael Trimble.
Is this better than? Okay. There are a few points I'd like to make first to correct. In his letter of September 8th, Mr. Kelleher said that I, at some point in my presentation to you, said that I did not believe Reading was in violation of the town code. My wife and I have gone over, it's on, we can get it off YouTube and get it off the end, I've gone over that over and over again, and at no time did I say any such thing. And it's there on Panda for anyone to see. Secondly, I believe that residents of the town who are concerned with an issue have every right to hire professional assistance, just as applicants do too, have every right to have legal assistance if they feel that's pertinent, particularly when discussions become entwined in legal issues such as this one is done. So my wife hiring an attorney from Albany who has experience in the mining operation to advise us on the issues and to provide information to you on our behalf, I think is perfectly justified and perfectly legitimate. I would also like to say, and I think the neighbors can also verify this, that until recently, if you have put up no trespassing signs, there were no trespassing signs on that property except for some beat-up sign on the gate, on that little gate between the 2 properties. There may well be now, and I think there should be. I think DEC also feels very strongly that mining sites should have no trespassing signs so people just don't wander out there. So, but I never saw one on the years that I've lived there. We've been going on 47 years, so There never was one that I saw, and I sincerely hope there will be now. I'd also like to basically speak to the issue of the appeals court decision. It's basically dealt with a piece of property that is not part of the current mine, the 37-acre mine, 57 acres. I am not a lawyer, which is one reason why we wanted to hire legal assistance, but I do not believe that the appeals court decision turned 37-acre legal permitted mine within the mining overlay district into a non-conforming use. I don't believe that's true. I don't believe that was the intent. It certainly wasn't in any way indicated. Therefore, what they are wishing to mine now is indeed a conforming use in the town of Rhinebeck, fully within the mining overlay district. Another correction I'd like to make. The planning board did not deny a permit to Red Wing for their mining. They did not have access they could identify to get to the mine. And if you look at the mining permit that the town does require, a special use permit, it is to regulate traffic on a town road if they're going to use a town road. Clearly, they want to use White Schoolhouse Road. Therefore, the town does have legal authority to determine the ingress and egress point, which they did not identify, so the planning board was not in a position to approve their mining application at that time. And it's my feeling, and I'll just keep it brief, that our town law does require a special use permit for a legally existing DEC permitted mine. That's what they have right now. The land that was the subject of the appeals court is currently under cultivation. And I have here the lease from 2023 for the local farmer up in Germantown for 57 acres, which will be continuing cultivation. I also have, they have applied for, and I believe they're being granted, an ag exemption. And what I have here is $430,000 off of the assessed value of their property, which I believe is in excess of $1.2 million, which is a fairly significant exemption. So agriculture is also a conforming use throughout the town of Rhinebeck. At this point in time today, there are no non-conforming uses on that property. So any use that is a conforming use does have to abide by the town of Rhinebeck zoning law. And in this case, for them to have that access road, they need a special use permit and site plan from the town of Rhinebeck. And I will hand this to you to hand on that. Thank you.
Thank you. Mr. Oplansky.
Thank you. I really didn't intend on you coming tonight. It's a holiday.
Ah, that's right.
You wearing it? And I wasn't intending on speaking, but I do want to make a few comments. I apologize if we violated the no reply rule, but we have to have an opportunity to respond to Mr. Kelleher's memo, and I responded to that in 5 days,
I'm not
several
concerned
days
about
before
the
the public
tit for
hearing.
tat.
I really
Nobody's gonna
sent
get the
those comments.
opportunity.
As far as the violation is concerned, I mean, the applicant is splitting hairs on whether he was in violation, or full violation, or partial violation at the time of the stop work order or notice of violation. The truth is that it's a continuing violation. There is no question that if you examine the road, which you will when you do your site work, there's an enormous amount of work that was done on road construction and the pertinent accessory facilities to that road. They didn't cut down just 10 trees. Just the road project alone is a huge project. And the applicant is essentially admitting that after they got the notice of violation, they continued to violate the notice of violation. The stay, while you appeal, doesn't mean that you have impunity to violate the law. It just means that we can't go into court and enforce that during the appeal. It's pretty outrageous for all this work to have been done if it was after the notice of violation. It was our understanding, though, based upon the comments that we had from our highway superintendent and other observants, that most of this work had been done at the time of the issuance of the notice of violation. like to just point out a few things that I pointed out in my letter. I'm hard pressed to understand Red Wing's arguments in their letters and communications with this board, where they argue several times that they have no intention of not complying with the town zoning code. And then they take the completely opposite, make a completely opposite argument that they don't have to comply with the town zoning code. I think Red Wing has to make it clear whether it intends on complying with the town zoning code with regard to the issuance of the special use permit and site plan approval for this mine. They made contradictory statements to the court below, to the appellate court, to our zoning enforcement officer, which I quoted on my prior letter to you, that Red Wing had every intention of making applications for a special use permit to the town. And now, relying on an interpretation of the appellate division decision, which I don't understand. I understand the decision, but I don't understand their interpretation. They argue that somehow the appellate division determination obviated the need for them to get a special use permit from the town. There is nothing in that opinion which states that. The only thing that opinion allowed Red Wing to do was essentially to make applications as a non-conforming use to the town and to DEC for their gravel mine. It did not say you don't have to make applications for what could be an enormous mine on that property. The other point I just want to make is the Partition Street case, which I'm sure you will have an opportunity to read. And the reason we cited that case, because it stands for the proposition that in that case, the access road to that facility was outside the district in which the property was located. And the argument was made that since it was outside the district, that the access road didn't require a permit. But that's what the appellate division held in that case, that even though it was outside the district, since it was a road appurtenant to the gravel mine, you had to comply with the district regulations. It wasn't the gravel mine, I forgot what kind of facility it was, but you had to comply with the district regulations governing that use. And subsequent to the last meeting, I found another case which is even more on point, which I cited in my letter, and that's the appellate division's second department decision. That was the third department decision, if I recall, in the matter of BBJ Associates, 6583rd 154, which I hope you will read. I'm sure you'll find it fascinating. But I'm just quoting from that decision, and it's a similar type of factual situation. The zoning board further concluded that since the purpose of the proposed town road will be to provide access from Route 52 to the senior housing community and no other access anywhere to anyone, it solely supports a single principal use and must be considered part and parcel of the principal use it supports. That's why I cited the Partition case, that's why I cited the BBJ case, and the argument is that even if you accept Red Wing's argument that somehow because of the property lying outside the mining overlay district, they don't have to file an application for a permit, which we of course disagree with, since the road is appurtenant to the property within the district, you, by virtue of that judicial precedent, you must make application for the permit for the road. And I think that argument extends to the additional 54 acres. There's 37 acres, which is clearly within the district. They have to make application for that. I don't know what their argument is that they, as to support the conclusion that they don't have to make application for that. But certainly the rest of the 95 acres, the 54 acres, that's also pertinent to the 37 acres that's within the district. By the same reasoning, even if you accept Red Wing's argument, they need to make application to the planning board. And what I'm really concerned about, and I think what the public is really concerned about, is what is Red Wing hiding here? The application to the planning board only means that the town will have, town planning board will have oversight over the permitting of this facility, and only in certain respects, because it's true, a lot of the town's authority with regard to gravel mines, as stated in the New York State Mine Reclamation Law, has been preempted by the state. But the town does retain a certain amount of authority over important aspects of the mine. And the most important aspect that's preserved to the town is to deal with the regulation of the access road and the truck traffic, and that's what we are all terribly concerned with in this town. We really want to know, more than just conclusory statements by Mr. Doherty, how many trucks will be used, what the size of those trucks will be, what the capacity will be, how many truck trips there'll be each day, each week, and that's all under the authority of the planning board. And I think it would behoove Red Wing to make that public during the application process before the planning board, and not fight the argument that the town has made that they need to come in and come into the fold and get the proper permits, because people are scared. They don't know what's going to go on. But if they do go before the planning board, and if it's really going to be innocuous, as they say, it's only going to be a few truck trips a day, so let it be. Let us know about that, and let the planning board regulate that. So I urge Red Wing to make amends and stop this nonsense, and withdraw this appeal, and make an application to the planning board for a special use permit and site plan for the gravel mine. And I hope you'll support us in that.
I did just one quick question.
Sure.
And
I don't hear very well, so.
okay. Well, I'll go. How's that? I'm in violation of something.
That's okay.
On the stay application, is there any case law that you're aware of as to the extent of the stay? I mean, is the stay meant to, stop the accumulation of, say, fines and things like that, versus the stay is meant to allow the work to go forward, kind of thing? And that's a big difference. And
Yeah.
I presume that there's got to be some case law on that,
Yeah.
talking about what the state
Well,
does.
let's look at it reasonably.
Well,
The stay basically says that if once you make your application to the ZBA, the enforcement of the violation is stayed. That means that if we filed a criminal action, which we had every right to do, when I say we, I mean the town zoning enforcement officer had the right to do, we couldn't do that until you decided your appeal. Or we couldn't bring an action for injunctive relief in the Supreme Court. We can't enforce it in that manner while the application is pending. But it doesn't mean that you've got a free ride to, during that period of time, violate the zoning law. And certainly if the Zoning Board of Appeals rules against the applicant, all of that work would have been done in violation of the zoning law and subject the Red Wing to penalties. And I think it would have been made a lot of sense for Red Wing to halt construction. I think when you see how much work has been done out there, you certainly have seen some of that through the overhead photographs that were submitted by Red Wing itself. You'll see that there was a reason why this notice of violation was served upon them. It wasn't because they went out and cut down 2 trees. It was because they had construction excavators out there. They were doing a lot of work, and there were a lot of complaints, and that was why the notice of violation was sent. But I don't think the stay, while we appeal it to the board, exonerates them from their continuing violation.
And I understand the argument from a common sense standpoint. I'm just wondering if there's any case law.
Yeah.
Because it does make some amount of sense that you not be allowed to go forward and build out and essentially get what you want anyway. But I was just wondering if there was any case law that talked about what the stay actually stays, so to
Right.
speak.
And I don't know if there's any, case exactly on that point. There might be. And I can look at it, and if I can find it, I'd certainly be happy to supply it to you. I don't know if John is familiar with that either, but we do have the right. I mean, if we felt the work has been done, when we got involved, when I say we, the town, that road had already been constructed. And when you go out there, you'll see the extent of the road construction work that was done. If they had continued to do that, and if they actually engaged in any additional activities or mining activities, we would have come before the zoning board and requested that the stay be set aside. And if we didn't get that relief from you, we would have gone to the Supreme Court. Because the work has already been done and we haven't seen any additional work being done during this period of time, we haven't done that. I can assure you that if it's Red Wing's position that while this case is being decided by the ZBA, that they have the right to go out there and start gravel mining, we'll see them in court.
Okay, I just wasn't aware of this is a very novel issue for us, quite
Yeah.
frankly.
Yeah. And usually, I've been doing this for many years. This is probably one of the only times I've seen where work just continues after the notice of violation has been issued. Usually, everybody has the common sense to put a pause to what's going on. But what I hear tonight is that Red Wing's position is very little work was done at the time of the issuance of the stop work order, and most of the work was done after that. To be honest, I wasn't aware of that. It was to our knowledge, most of that work had been done at the time of the issuance. But it makes no difference. Ultimately, if they're in violation, they're in violation. Thank you very much.
Or
Unless you have a question.
anybody else have any questions? All right, I don't have anybody else on the list here. Is there anybody? Okay, come on
I
up.
have a question.
Okay, come on up and state your name and your address and the question that you have.
Excuse my nerves. My name's Sean Bowen, 219 Slate Quarry Road, the White Schoolhouse. My wife spoke last time we were here. I'm concerned about the traffic. I take White Schoolhouse Road to be safe to pull into my driveway most of the time, except late at night, because I don't like making that left-hand turn. I was coming home last week, and one of our local dump trucks that used that road came through the intersection with me coming out, and it scared me, and we had words, we're fine, but he said that the turn is so bad for trucks turning left that they have to gun it to go across the road. So if that's going to be happening 10 times a day, 50 times a day, or whatever, there's going to be trouble there. I wake up hearing skids going into our house or by our driveway on rainy days more times than not. I'm the first caller to 911. They know me. The cops know me. I give beanie babies to little kids who are afraid to get back in a car. But there's accidents there. There was a death in my driveway, and I am concerned, and I just want to know when we can bring that up as a major issue. If they're going to have 99% of that stuff coming out of Slate Quarry Road and turning right and turning in, there's going to be accidents. I just have to say that. Thank you.
Could I just ask you, are you the house that has the big fence there?
Yeah,
right
I'm the
at bottom
house
of
that I have pictures on my phones of cars flipped over. I have a little PTSD from it, to be honest with you, but we love our home. We've done a lot of work to it, but it's frightening to know that these trucks are going to be coming there upwards to 80 times a day, or, well, whatever. So, thank you.
Thank you. Is there anyone else here? All right, Mike, leave. And Mr. Kelleher, feel free if you like to get back up.
I realize I neglected to identify who I am. Michael Trimble, and I live just down the road on Slate Quarry Road. And I can certainly back up everything Sean has said. The state police give me flares because they know I'll be one of the first people out of accidents. So, and as many people know, there's no cell service where we are. We have a landline, so we're very often people also punished. But it is very dangerous. I don't know another road in Rhinebeck that has flashing lights at the top of the hill and then exits out onto a major state highway. But the one question I had, there's been a lot of discussion about the court decision absolving Redmond of having to apply for any permits. And I guess one thing that's never been brought up, I don't believe you're saying that you do not have to apply to DEC for a permit to mine on that portion of the property.
We already have.
No, a permit was put in. It has not been accepted, and it has not been approved.
Pending. It has been.
It's pending, but it has not been accepted.
It's been pending through this whole litigation, the prior litigation.
Well, I know that it was originally submitted in 2008, this is 2021. So the question I'm asking is, you do acknowledge that you do need a DEC permit to mine on that property, both within the mining overlay district and outside.
We understand that.
That permit has been pending for years, and the DEC has been delaying based on the appellate division's decision. They now have provided us with that decision. They gave us a permit to build that road and for an incidental take permit. We've already dealt with the DEC, and the DEC is separate in and of itself.
My question is, that you do acknowledge you need a mining permit to mine outside of the mining overlay district.
We've been doing this for 50 years, Mike. We know what we're doing.
I know you have. I just, that has never been discussed, and I thought it was
No.
good to get that mentioned.
The DEC
We know
permit
that.
and a special use permit are completely different things. But yes,
Thank you.
we are doing that, and we have been doing that. And they have permitted us to do the work, which we've seen.
Okay, is there anyone else who would like to be heard? Come on up. I just had a quick question. It's to Mr. Keller, and maybe I'm concentrating on the wrong issue, but it's on the stay issue, and I was wondering if you were aware of any case law that talks about the scope of a stay. I know that you've been hanging your hat on that, and I'm not saying you're wrong. I'm just saying that you've been hanging your hat on the argument that we have a stay, we can do whatever we want, kind of thing. And I understand the argument that Mr. Raplansky made, and I'm just wondering if there's case law. It would seem to me there should be some case law on the issue of what does the stay actually do? Does it allow you to do whatever you want willy-nilly, or does it simply stop the accruing of fines and that kind of stuff? Does it stop judicial intervention, as mentioned by Mr. Raplansky, that kind of stuff? I have a question.
I haven't looked fully into the case law. But I think our argument is not that we can just do whatever we want. Our argument is, as of April 27th, which was the date the violation allegedly occurred, there wasn't a violation. No violation occurred on that date. And the stay occurred, so then we put the stay in, and yeah, then there was some activity afterwards, as we've been quite transparent on. What that means, I don't know. We might have to do some research.
Yes, because, I mean, I think the issue really hasn't been addressed as to the extent of the stay. And if the stay is meant to simply say, all right, you cannot enforce fines or that kind of stuff, that's one thing. But to me, there's a common sense kind of argument that filing an appeal shouldn't allow you to get what you want in the first place, and that is to just go forward and continue to bill, which is apparently what occurred here. I could be wrong. I don't know what the case law is.
Right, we can look further into it. I don't have any cases.
Okay.
Either way.
Okay. Anyone else? Okay. As I indicated at the beginning, my intention is that we do want to go out and we do want to do a site visit. And we'll do that before the next meeting. But what I'd like to do is to continue the public hearing until October 20th. So that gives us an opportunity to go out there, walk the roadway and the site. Well, I'm sure we'll have questions that we'll want addressed at the next public hearing on October 20th. So that's my intention. John, do you have any quarrel with that? Or?
No, I don't. The parties should know that it's probably a very good chance that the public hearing will be closed at the October 20th meeting. So any materials that you want to get in front of the board, please make sure that they're submitted ideally before that meeting.
Yeah, and thank you for adding that, because we have heard a lot, and I appreciate all the input from both sides. And again, everybody has been very respectful, passionate, but respectful, and that's fantastic. But these things have to come to an end, and they've been briefed pretty heavily. So get whatever you want to give us, by the 20th of October, please. And then we'll contact you about arranging a site visit by the ZBA here. And
Yeah, and we may want to, just as a suggestion, we may want to have 2 dates, a rain
Yeah.
date as well,
Oh,
because
sure.
it is obviously been a rainy summer and hopefully not fall, but it's been quite rainy, and as we've been out there already, it can be a real mess.
It's coming up pretty good.
Oh, is it? Okay.
okay, so we'll be in contact with you on that.
Okay.
And just
All right.
for the public, just as a reminder, just keep an eye on the town's website if it's going to be virtual or in person. Just keep an eye out just so that you know where to log in or come.
Okay. So again, I probably appropriate for me to make a motion to continue the public hearing until October 20th. So I make that motion. Do I have a second? Okay. I have 3 seconds. All in favor? Aye. Opposed? All right, great. Thank you, everybody. We'll see you on the 20th.
Well, we have other agenda items, so just if you have anything else.
Yeah.
Thank you.
All right.
Got my email too, so you
Yeah, right,
copy,
yeah.
just copy me too. That way we
Yeah.
I think the board may want to.
5 minutes break.
Yeah, we can have a 5-minute break.
And was your number?
We're going to take a 5-minute break.
My phone number?
Catherine, take it away.
Okay,
This is the Rugies resolution.
yes, it is. In the matter of the area variance application of Ruby's 9G Properties LLC, ZBA case number 1016. Whereas the applicant is Ruby's 9G Properties LLC. They are represented by Mark Berminski, PELSPC Consulting Engineer and Land Surveyor. Property involved. This appeal involves property located at 3667 Route 9G in the town of Rhinebeck, and which bears the tax parcel number 1350896171000862418. The applicant's property is 3.11 acres in area and is located in the BP zoning district. Description of the proposed project. The applicant seeks to change an existing sign on an existing car dealership from Rhinebeck Ford to Ruby's Ford. The total signage will be 178 square feet. It exceeds the maximum total signage allowed in the district, which is 30 square feet, but decreases the existing signage by 7 square feet. A previous area variance was granted by the ZBA in 2016 for a total of 185 square feet. Section 12537K2A of the Town of Rhinebeck zoning law states that the maximum total signage shall not exceed 30 square feet for the lot. The applicant is requesting a total of 178 square feet. One area variance is required for 148 square feet. Timeliness of appeal. The applicant filed an appeal with this board on June 22nd, 2021, and has paid the requisite fee. The appeal was filed within 60 days of the date of the ZEO's determination letter dated June 8th, 2021, which is being appealed, and thus the application is timely as required by Section 125.125B of the Town of Rhinebeck zoning law. This application was reviewed and accepted by this board on July 21st, 2021, and deemed complete. Secra. This application is a Type 2 request under Section 617.5C22, which covers installation of traffic control devices on existing streets, roads, and highways. This includes the installation of signs. No further environmental review is required. Referrals or responses. The application was referred to the Town of Rhinebeck Planning Board following the ZBA acceptance of the application as complete. The Town of Rhinebeck Planning Board responded on August 2nd, 2021, stating they saw no significant planning or environmental concerns. The application was also referred to the WAC as it is within the LWRP. The WAC responded that there would be no impact on any wetlands or any detriment to the character of the neighborhood by granting the variance. The application was also referred to the Dutchess County Planning Board as a non-residential area variance within 500 feet of right-of-way of State Road 9G. They replied on July 22nd, 2021 that it was a matter of local concern and provided no additional comments. Public hearing. A public hearing on this application was advertised and held on August 18th, 2021. There were no comments from any member of the public on this proposed project. The public hearing was closed on August 18th, 2021. Site visit. All members of the ZBA indicated they were very familiar with the applicant's property and the surrounding neighborhood and that there was no need to schedule a specific site visit. Findings of fact and conclusions of law. Balancing test. In our review of the variance sought, we have considered the benefit to the applicant if the area variance is granted as weighed against the detriment to the health, safety, and welfare of the neighborhood or community by such grant. We determined that the variance requested should be granted because there is no perceived detriment to the health, safety, and welfare of the neighborhood or community by the granting of the variance. Consideration of five-factor and balancing test. In our determination, we have considered the 5 factors required by Section 125.124C1 of the Town of Rhinebeck zoning law as follows. If the variance is granted, will it cause an undesirable change in the character of the neighborhood or cause a detriment to nearby properties? We find the answer to this question is no. The new signage will cause no change in the character of the neighborhood. In fact, it will reduce the required variance by 7 square feet. The materials and design of the sign will match what has been there for some time, albeit with a slight reduction in the overall size to what is presently there. Can the benefit sought by the applicant be achieved by some method feasible for the applicant to pursue other than this area variance? We find the answer to this question is no. The change in ownership brings with it a change in the branding of the dealership. The signage is in the same area and in the same style as the current sign, but with fewer letters. Thus, the change mitigates any impact on the neighborhood. Are the requested area variances substantial? I guess that should be singular, actually. We find the answer to this question is yes, if measured in purely the amount of square footage requested. However, the variance is not substantial if one considers the size of the property, the design of the building, and the placement of the current signage. The sign is approximately 100 feet from the roadway and appropriate for the scale and frontage of the building. It is readable but unobtrusive. Furthermore, the new sign will reduce the size of the present sign. Will the proposed variance, oh, I thought I got all those singulars. Will the proposed, I think I need 2 templates, Kim, 1 plural.
Need a good secretary.
Yeah. Okay, I have a few, I can make these changes for you, Chris. Let me see, where were we? Will the proposed variance have an adverse impact on physical or environmental conditions in the neighborhood or district? We find the answer to this question is no. As mentioned above, the new sign replaces one of like design that has been there for some years. The prior sign also has had a variance for size that was granted in 2016. There is no change in impact on the neighborhood or in environmental conditions. Is the alleged difficulty self-created? We find the answer to this question is no, and that a change in ownership necessitated a change in signage to communicate that change to the public. Minimal variance requested. In addition to our review of the 5 factors and balancing test, we must also determine if this requested variance is the minimum variance necessary and adequate to accomplish what is requested by the applicant. We find the answer to this question is yes. The changes requested meets the needs of the new branding with the least amount of change overall. Now therefore be it resolved, based on all the facts described above and upon the reasoning described above, as follows. The ZBA hereby grants the variance requested by the applicant, finding that the benefit to the applicant outweighs the detriment to the health, safety, and welfare of the neighborhood or community by such a grant. As discussed above, the change in the content of the sign reduces the size of the variance required with no impact on the neighborhood. The granting of this variance is expressly contingent upon the following: that the installation of the new sign conform to the plans as submitted. The granting of this variance shall also be expressly contingent upon the applicant's full payment to the town of Rhinebeck of any and all fees and escrow deposits due in connection with this application, in full compliance with Article 14, fee reimbursement of the town of Rhinebeck zoning law. This variance shall not be deemed valid until all such fees are paid in full by the applicant. The granting of this variance does not absolve the applicant from having to secure any other required permits and/or approvals. The area variance shall be null and void unless the proposed construction is commenced within 1 year of this resolution.
Nicely done. Do we have any discussion?
No, I think that's it. Thank you.
Yep.
I just have one, on paragraph 5, on page 1, it should be a type 2 action.
Action, okay,
That was it.
okay. And then, Chris, I had a few other little typos on those sections, but I can update my file and send it to you so you don't have to worry about it.
All right, okay.
Whoops, excuse me. So,
Yep.
any other questions or discussion?
No, I thought it was pretty straightforward and
Okay.
really an easy one because, you know, it's a little less in conformity with what's there. We gave, I mean, I was actually present for the last variance, and I think it fits perfectly, and it's just big enough so you can see it from the roadway kind of thing, and absolutely appropriate. That's just my opinion. So, any other comments, concerns, questions? Would you like to make a motion?
Yes, I make a motion to approve the resolution.
And I will second it.
With the,
With
With those changes.
the changes as discussed, which I will send on to Chris.
And I will second that.
Okay.
Chris?
Scott Bergen,
Yes.
Catherine Clark,
Yes.
Tim Econopoulos.
Yes.
Sorry, Richard Kopizinski.
Yes.
All right, well done. Enjoy yourself. Wherever you're going in October.
I'm going 2 places. I'm going to Santa Fe Monday, and then when I come back, I'm going to go to Kansas in October.
Good for you.
Where's the second one?
All right, well, let me just end the meeting before we,
yes.
the pleasantries. Any other?
Motion for Catherine to go to Kansas.
Yeah. To allow her to go to Kansas,
Yeah.
that's right, leave the state.
Home again, home
Yes.
again.
Any other things that we should discuss?
Well-
Kim, John, or?
Did you want to
We can
sort
discuss.
out in-person versus,
I think we're at the mercy, I don't want to say mercy, but whatever the town decides, I'm willing to abide by. If they want us to be virtual, that's fine. If they want us to, if they'll allow us to be in person, I prefer in person, but that's just my, proclivity. So I think we're governed by what the town wants.
is the town board asking boards to make their own decision, or are they issued a suggestion or guidance to all the boards?
So it seemed optional, the original email. Didn't
I
seem
also-
like it was a straightforward,
I don't think they found somebody to run the meetings
But-
either, have they?
the town board
Not yet.
and the planning board have gone virtual. The only thing, planning board will be going virtual. The only thing that I don't know about is the live streaming and what that
Yeah,
will
we'll
entail.
Tim and I will sort that.
Yeah,
with you,
so,
but,
but they're looking for one person to do all meetings, rather than one person to do individual meetings. Like a planning board have their own, ZBA have their own, they wanna get one person to do everything.
What do you guys prefer? I mean, this is a democracy, so I'll go by with it, whatever everybody else wants to do, but I'm fine
I
coming
would
by.
prefer virtual. I mean, wearing the mask and like a lot of times I can't really even hear it.
Yeah, I can't hear. I still prefer
Right.
being here, but I have trouble hearing sometimes too.
Yeah, reading a resolution through this mask, I thought if I pass out, they'll pick me up, I guess.
I'll catch you, I'll catch you
Well,
before you fall.
once the meeting is over, certainly.
Yeah.
Did you say Jay?
All right, so I guess it sounds like folks are leaning towards virtual, so we'll go virtual if that's what
I
is
certainly-
being requested.
I certainly don't think when we did the virtual meetings, we had less participation.
Oh, no, it was
I thought
fine.
it worked out pretty well, actually.
Yeah,
Yeah.
it's just so nice to be alive, that's all. But I'm fine with the virtual, so we'll go with that if that's
And
available
we'll
to us.
see, we'll see how, whether conditions improve, I mean, at some point Delta in other areas has been, receding a little bit.
Yeah.
So we'll just have to see. We will talk to Chris about, we'll sort it with the town, not you, but, the live stream is not a requirement. And,
Legally,
right,
yeah.
so, and it's complicated. So, if we do virtual, I'll work it out with Kim, but we'll probably just do regular old Zoom meeting with Kim hosting
Okay.
and, do it that way.
And you two gentlemen, using the term loosely, will be available for the next meeting?
And then, so for Jordan, I guess we'll have to confirm with Jordan about what we're doing, so you know what's going on, yeah.
Yeah.
Thank you, by the way. for
Yes, thank you for
having
it.
me here. It's always nice.
Thank you very
It's such an
much.
important function.
It really is, it really is, thank you.
Yep.
All right, and so we're confirmed, we do have a quorum for the 20th, so we'll definitely have 3.
Yep. And I did thank the police officer that was here, Officer Imparato, for coming, which is very
Yeah.
nice always to have them there too. But if we do decide to go virtual, we'll have to, I think they have a standing order to come to ZBA meetings for the moment. So we'll have to make sure that that gets communicated.
Is that because of Red Wing? The whole-
That was, actually has more to do with the mask.
The mask.
We didn't anticipate, and it's just that, as you know from reading the papers, there have been some instances where tempers have flared over that issue.
Especially on flights.
Yeah,
There's a lot
Well,
of terrible
anywhere,
things happening
you know.
on flights.
Yeah.
I just don't understand.
yeah. But I think it'd be appropriate to close the meeting if we want to discuss that issue further.
Certainly, I don't care. We will, I make a motion that we adjourn the meeting. Do I have a second?
Second.
All right, all in favor?
I
Aye. Aye.